Recording in progress.
Good morning, ladies and gentlemen. Good afternoon, dear colleagues, dear guests, dear students. It is with great joy that I chair this virtual meeting today in the 17th edition of the International Law Winter Program of CEDIN. First of all, let me thank to Professor Leonardo Nemer and the colleagues from the CEDIN and the Konrad Adenauer Stiftung for this kind invitation. Year after year, CEDIN consolidates itself as one of the main think tanks in Latin America and in the discussion of global issues. And for almost 20 editions, its winter program has gathered the critical mass of international law scholars, diplomats, international lawyers, etc. This is the reason why I am always deeply happy to accept this invitation. Thank you to CEDIN, to Konrad Adenauer Stiftung, and especially thank you, Professor Leonardo Nemer. So, in my name and on behalf of Professor Nemer, welcome to this very special session today of the CEDIN's winter program, when we have the pleasure to listen to one of the greatest names in the international scenario, my dear colleague, Judge María Teresa Infante Caffi of the International Tribunal for the Law of the Sea, with whom I have the honor to share the membership in the International Law Association and in the Instituto Hispano-Luso-Americano de Direito Internacional. Judge Teresa Infante is professor of law at the University of Chile and also professor of the Diplomatic Academy of Chile. Before joining the Tribunal of the Sea, she was ambassador of Chile to the Netherlands and permanent representative of Chile to the Organization for the Prohibition of Chemical Weapons. Currently, she is the president of the Chilean branch of the International Law Association. Previously, she was president of the Latin American Society of International Law. She is a member of the Instituto Hispano-Luso-Americano de Direito Internacional e member of the Instituto de Droit International. In her today's conference, Judge Teresa Infante will talk about natural resources in common spaces, development, and regimes. Judge María Teresa Infante Caffi, sea muy bienvenida a Brasil nuevamente. Muchísimas gracias por su presencia. Es un gran honor recibirla. The floor is yours.
Muchas gracias. Muy agradecida. Thank you very much, Professor Marcílio Franca. I would also like to thank Professor Nemer and the organizers of this course, which is to which it is an honor to participate to. I'm really delighted to be in front of you and to receive your questions and comments. If you allow me, I will lecture in English, but I can move into Spanish if needed and if my English is not clear enough. I have no problem with that. It is a pleasure to continue a tradition and to teach before a young audience in a Latin American country which is so productive in the sphere of international law. I was just going through some statistics yesterday of universities in Latin America, and I think the Brazilian universities rank very high. And this is one of the demonstrations or of the proofs of this engagement with knowledge, research, and also dissemination of knowledge. Let me share some slides in order to follow and to structure my presentation. I will address two, let me see. I have to go to here.
Share screen. You have a green button?
Let me see.
Yes.
Is it okay? No.
Yes, we can see.
You can see the slide?
The slides, yes.
Oh, let me see, because I'm not seeing anything. Let me see. Oh, I made a mistake. I don't see what I'm showing, but if you see, that's okay.
No, we can see all the slides
All
together.
the slides.
All the slides, yes.
If I'm,
I think you have to now to press something to just to show to start the presentation.
Slide. Maybe because. Let me see. Now, this is the slide. This is okay?
Not yet. Yes. Now?
Now it's okay.
Yes, perfect. Okay.
And can you see me? Yes, you can
see
me. Okay, good. Well, I have chosen a title that is broad enough in order to encompass two different areas which are subject to ongoing negotiations and discussions. None of them is deprived of discussions, harsh analysis, controverted issues, and also regional and national positions. It is the question of natural resources in common spaces. And in order to go to the follow, yes, okay. And now we move to the, I know what happened. Well, this is okay. I'm going to depict the subjects through a general index. Biodiversity beyond national jurisdiction. It is a negotiation in motion. Because of the pandemic, the negotiations have been slower than thought and than planned. The program of work has been a little bit deferred because of the lack of in-person meetings in New York. But it doesn't mean that the negotiation is not alive and is not receiving inputs and subject to harsh debates on certain issues. I must say that all of the issues are very rich in terms of thought-provoking, and at the same time in terms of illuminating or enlarging proposing a wide picture of subjects that will have to be addressed by the states and international organizations and NGOs and the civil society as well. The other area is seabed minerals, where there is a regime, but the regime is being, to some extent, supplemented and deepened because the mining code has not yet been fully completed. There is one chapter still missing, is in the hands of states and the international civil authority, which is the exploitation chapter of the mining code, which means that with the mining code, completed mining code, there will be possibilities for accessing to exploitation contracts, plan of works, to exploit those resources. And what is the importance of the resources? We're going to look at the details of this matter. Of course, in both cases, in both scenarios, there are challenges, many challenges. Challenges that are related to political constraints, challenges that are related to other negotiations that are taking place in the international sphere. For example, biodiversity to some extent has an impact on minerals, and minerals cannot be taken in isolation in respect of biodiversity because there are some interrelated matters like For example, on environmental impact assessment, on the question of marine protected areas, area-based management tools, and so on. And of course, there are many existing frameworks that are already in place, being applied to the areas in which this biodiversity and these mineral resources are based. Let us look at the general picture of the situation in the seas. We see the natural jurisdictional zones, or zones of national jurisdiction, which is a worldwide covering part of the seas, part of the planet, and high seas. High seas is a concept which is not obsolete. On the contrary, it is interrelated with zones of national jurisdiction in terms of regimes, in terms of resources, activities conducted by states and other subjects. Some of them are non-state actors, like, for example, piracy in fisheries, and so on. And also because of the high seas is a component of a single process of nature. Let us see at another slide I took from the web. This is not my creation, and I have to pay what I could say intellectual property rights, symbolic ones, to look at to have a different picture, to look at the high sea scenario and the maritime scenario. Zones and their governance patterns. When we speak about resources like biodiversity and minerals, we have one window from which to look at the details and particularities, which is what are the governance patterns applicable to those resources? What are the institutional arrangements applicable to those resources? What are the entitlements that may be present in the areas where those resources are present? Some resources are located within and beyond national jurisdictions. Some resources are collected within and beyond. So it is a very complex picture in terms of geography, in terms of illustration. We have here some samples of governance patterns. Let us look at the surface. We do have here, or I don't know if you are seeing CBD, the Convention on Biodiversity, when it applies to maritime zones subject to national jurisdiction or activities conducted by states parties to the convention. Biodiversity, which is a definition adopted in 1992 in Rio de Janeiro, and it's still in force and has given place to other instruments. The Convention on Biodiversity is one governance pattern. Another one, regional seas programs that were envisioned by the environmental or the UN environmental program, and that is to some extent the source of a network of instruments to deal with land-based sources, with pollution in the seas, but mostly focused on the relationship between coastal states and the adjacent maritime spaces. Then we move into the high seas as such, and we look at the role of FAO, the Organization of United Nations for Food and Agriculture. What is the importance of this? It is the competence of FAO reflected on several instruments, soft law and hard law, regarding fisheries and fishing activities. Very important ones. Why are they so important? Because they have tried, or they are aimed to foster a stronger and a more accountable relationship between states and activities conducted by vessels, entities flying or flying the flag of, or flying vessels, and vessels flying the flags of certain states. And we also see the regional fisheries management organizations that have been established in several regions that are more or less effective and that are dealing with several objectives, purposes like conservation, ecosystem questions, the question of determining or establishing quotas and adopting compliance measures, and also trying to settle disputes between competing interests that may be a cause of friction between fishing nations. And an old-time convention, the Wales Convention, which is a convention that has had to adapt to new times, to the new law of the sea, because it preceded the UN Convention of '82. But this adaptation still brings the idea of a kind of interrelation between commercial activities, scientific activities, and protection and the prevention of the exhaustion of certain resources, which is an instrument that should be more adaptive. It has not been absent of conflicts and tensions between parties. And the Wales Convention reflects the time in which it was adopted, which was a time of open high seas, and where states that converge into an activity had the power to control that activity, but they were not controlling the allocation of rights. They were only cooperating in terms of conservation when they had they reached an agreement, and in terms of some technical and scientific data gathering. And then we have at the bottom the International Civil Authority, which is a very important. It was a far-reaching concept at the time, still is. It is an organization of a unique model in the world that has the power to manage resources that are subject to a concept of which we're going to talk in our lecture, which is the common heritage of mankind. Let us move to the next slide. Now, the first part of my lecture will be devoted to biodiversity beyond national jurisdiction and the emergence of a regime in the law of the sea. This will be repeated throughout the lecture, and we're going to go back to the basics of this negotiation. We have a full range of issues that invite different perspectives to enrich the debate. First, we have facts and practical data. What is it about? What is this biodiversity? What kind of elements? What are the elements? What are the materials of this biodiversity that will be targeted by a future convention? All sorts of species, or some of them. Second, the geography of the subject. Where? And the geography could be modeled. Can we introduce through area-based management tools a new modeling of geography, taking into account specifics of certain areas? Then definitions. Let us move to the next one. And the next one is the following. I have taken a source, which is the WWF, which is, I will call a scientific, but also a a policy-oriented entity, an NGO, but a very important one, that says that marine biodiversity includes coastal and marine plant and animal species, their genetic variety, the habitats and ecosystems they form part of, and ecological processes that support all of this. So it is a very comprehensive concept, marine biodiversity. We have to take into account this diversity, but it doesn't mean that all of the species will be targeted, will be encompassed by a future convention, a future binding instruments, as it has been defined by the negotiators. It is WWF says that it is more diverse than diversity in land or land, and it creates, of course, a lot of challenges because of the unknown components, because of the lack of impact assessment so far, and so on. And then the question of community characteristics of recognizable habitats. It's very interesting. Let me see. We move to the next one. And the next one brings us a more analytical approach. We have to look at the structural elements of the debate. It is only a scientific debate, but it is also a debate in which we include political elements and legal elements, and also institutional building elements. Here we have the appeal to international law. I strongly believe there is a place of international law. It is not only a scientific matter, and it is not only a political matter, and not even a commercial matter only. And this is important to take into account, at least in the current stage. Commercial, in the broad sense, or economic values are important, and maybe that is the attraction for some states to be present, or some entities to be present in the debate. But the place of international law is to not only to bring those elements together, but also to organize a coherent system. So we have to look at pathways for ocean governance and the legal status of access. What is access to those resources that are placed in the high seas? And that may be intertangled or maybe intertwined with minerals that are present and that are part of a common heritage of mankind. Of course, the distinction between regimes already established and regimes to be established is important. There we have the tension that emerged. It was in, I must say, 20 years ago, more or less, in the framework of the civil authority, the tension between those supporting a common heritage of mankind approach and the approach that is more limited one, which is based on the concept of benefit sharing and the idea that we have to fill in gaps, not to leave gaps in a regime. So these are the structural elements of the debate. Let us move to the next one. Issues and problems. A comparative perspective, which is, let me see here. Okay, a perspective which is a different one, but which is absolutely complementary or supplementary to the previous one. We have issues and problems in this structure through which, or we're trying to build in, is sharing benefits. This is one thing. What are the benefits you are going to share? It is through technology development and transfer of technology, through other means. Then we have the question of human, institutional, and technical scientific capacity development. This is essential. This is part of of this all-encompassing discussion, not only legal aspects, but the law applied to a subject, to a problem, if we may call it that way, to a problem which is, if it is not going to be a common heritage of mankind, and even if it was going to be, if it were to be a common heritage of mankind issue, how are we going to develop and foster and enhance human and institutional and technical capacity development? That is very important. This is not something that goes on without having a very clear thought, a very clear view about what is it is at stake. This is very, very important. Very important. So we have, and then we have International Marine Scientific Research Cooperation, which is maybe one area of this development and transfer of technology chapter, and sharing results, data, knowledge, information, and samples. Very important issues. Let me tell you that, let me tell you something which is an anticipation of something I have to address very generally. You see that through that view, where there will be benefit sharing through cooperation on technology and scientific research development, we will have to find a moment, we will find ourselves in a moment looking at intellectual property questions, issues, and the regimes already in place on intellectual property. That is something very important, and I think you as young students, young academics, researchers will be able to look at those areas and their interrelationships. Ocean governance, in this perspective, looking in a kind of timeline from the past to our days, we see a dynamic process. 2011, there was a breakthrough moment where, within the UN, two main concerns. 2011, it was the year before Rio +20 conference. States realized that they had to address two main concerns. The legal gap that may have been present regarding biodiversity, a legal gap. It means that there were insufficient elements to address, to have a full picture and address the governance of those resources, where the distance between those having access to the resources, developing scientific research and applied research, and with the technology and patents and so on, and commercial use of these resources, the gaps between those and other states could be widened. So that is the question of where law has to be brought in. And the application of high-seas freedoms and conservation instruments were seen as insufficient. And second element is the question of intellectual property as an issue, because intellectual property is part of the rule of the games when you apply to plants, species, some knowledge, and you introduce changes that are patentable. That is important because of the current regime. Patents have a positive side. It is not only protection, but you have to disclose the knowledge that is behind that. But at the same time, the use of patents may be subject to certain conditions and constraints. And then in 2012, in Rio +20, states recognized the importance of the conservation and sustainable use of marine biodiversity beyond areas of national jurisdiction. noting the ongoing work at the General Assembly. This is a very polite sentence, and of an ad hoc open-ended informal working group to study issues and so on. It was a kind of a clearinghouse where you put knowledge to discuss questions, but there was no systematization. But then the state decided to build on the work of the ad hoc working group, and before the end of the 69th session, to address on an urgent basis the issue of the conservation and sustainable use of marine biological diversity of areas beyond national jurisdiction, and to take a decision on whether or not to adopt what is called an international instrument under the UN Convention on the Law of the Sea. What does it mean? It means that the distribution and allocation of maritime spaces was going to be respected. The entitlement of states was going to be respected. The powers of the civil authority were going to be respected. But in between, there were areas in which regulations were going to be developed and adopted, if possible, by agreement. Let us repeat again the importance of science and technology and the sustainability of the economy based on marine genetic resources. This is something that illuminates this debate, Rio +20 debate. Science and technology and the sustainability of the economy based on marine genetic resources. And this sentence, which is important, which is country research is unequal, and so are the possibilities to get benefits from BB&J, biodiversity beyond national jurisdiction. So this is the question. It is the difference or the differences between states and equal opportunities. It is not because the international system is based on unequal possibilities. It's not that. The question is the economic relations give the opportunity to participate, but at the same time, the path that states are following are not equal or are not based on equal knowledge, equal possession of the knowledge, and so on. Let us look, it is just a refreshment of the other side of deep sea minerals resources. This is much older. Biodiversity is a new area. It's an area of development with an increasing economic interest and strategic interest. Medicine, pharmaceutical activities, and so on. And mineral resources is an old time interest of states and entities. And it's called operators or contractors, potential contractors, and so on. Even, of course, with some strategic inputs. What are the grassroots of this? Let us look at the resources. Resources have been assessed and have been identified many decades ago. We know there are some polymetallic nodules. This is the first photograph. We also have polymetallic sulfides, which is the second, which appear in certain areas where there is a contrast between heating areas and the cold sea, and cobalt-rich ferromanganese crusts. These crusts have also an importance because of the cobalt-rich elements that are present there. And for this, we established in 1982, in force since 1994, with some amendments that allowed the convention to enter into force in a more stable way, which is an authority, an organization that has a competence which is unique in the world. It is the organization that manages what is called the common heritage of mankind. The discussion about the component of this principle is a discussion that is still present, but the convention limits the common heritage of mankind to minerals. It doesn't mean that the international community cannot apply this concept to other resources. But in the convention, the regulation that is allocated to the International Civil Authority is confined to minerals. But it doesn't mean that the organization is alien or should be silent or blind to developments related to other resources that are found in combination with those minerals. So that is the richness of the comprehensive approach. And here we see the question of the area and agreements applicable to the area. The area is a legal definition of a marital space in which and on which the common heritage of mankind applies mineral resources, which are those resources that were shown before. And the definition is subject to a full development in the UN Convention on the Law of the Sea, which is part 11 and some annexes, which is not only about the organization, it is also about the behavior of states participating, the behavior of potential and contractors that contract or enter into agreements with the authority, which is the manager of this international seabed regime, and also dispute settlement procedures, which are very comprehensive and that cover all sorts of disputes between different parties, private, public, international authorities, states, and contractors. And then we have the agreement of 1994, which was the agreement adopted by not only by state parties, but all states, members of the UN, participated in the negotiations that change the approach in certain areas. Technology, transfer of technology, the question of the policies applicable to production policies, and the introduction of WTO disciplines into the commercialization of these minerals. This is something we're going to see tomorrow in more detail. Current challenges in seabed mining are several, although there have been developments on prospecting and exploration, still pending the exploitation chapter. So the final step is pending, and what is pending is the adoption of standards and guidelines, and also the exploitation regime itself. The question of sustainability and governance of a system. Sustainability because in the meantime, the international community has adopted the goals for sustainability. It is SDGs in 2015, preceded by the Millennium Goals, but those goals are covering different areas, not only the question of accessing and benefiting from resource exploitation, but also question of social goals, environmental goals, development goals, and so on. So the organization is participating in that new agenda of the international community, which is a vivid agenda. States are notifying about their determinations in this respect. And it may be that this seabed mining regime has also to take into account questions like climate change and other environmental concerns. So crucial points are very rich. And of course, negotiations of biodiversity, which are located in the same area as these mineral resources are very complicated to integrate in the full picture, but we have the responsibility to do this. Let us go back to biodiversity. When we look at resources or the marine genetic resources and biodiversity, I have read some studies, and I have the reference here, that say that 98% of 1,600 or 1,600 gene sequences associated with species found in deep sea and hydrothermal vents are owned by subjects located or headquartered in only 10 countries. This is a political fact and an economic fact. This is a negative fact. Well, it may be neutral. It depends on the use. It depends on the activities. It depends on the associations and so on. But this fact shows that this is already a pathway that has been undertaken by some subjects and some companies or entities. A blue paper wrote and published in 2020, which is in an association which is a like-minded association called the High Level Panel for a Sustainable Ocean Economy, which is run by Norway, with states participating from different regions. Not many, but it is a voluntary association. Says something that is very interesting. It says that the ocean genome is the genetic material which is a pillar of global food security and human well-being. It is the foundation upon which all marine ecosystems, including their functionality and their resilience, rest. So the importance of this ocean marine biodiversity is enormous. And through fisheries and aquaculture, we're dealing with this biodiversity. And the functionality of the biodiversity and this marine ecosystem, the functionality is very important for conservation and future use of the resources. We're going to go to country affiliation of scientific literature focus on marine genetics, and this is something which is very striking. You see states. We see author affiliations. This is a publication by the government of Fiji, and I think it is very accurate. You see the United States dominates the area, the capacity of universities and scientific laboratories and so on. The UK, Germany, Japan, France, China, Canada, Australia, Spain, Italy. And then we should continue. It is a worldwide scientific literature. It doesn't mean that this literature is only focused on marine biodiversity. It is the ocean genome conservation and the question of fairness in accessing and profiting and the knowledge that is being disseminated. Then we see another slide showing, which is this is an assertion I have taken from some authors. There is an unbalanced ownership of patent claims. Some pattern and similar set of countries for patent claims associated to human sequences from the 4 crops most cultivated and so on. The idea that there is a disequilibrium, so unequal enjoyment of this. This is also important. We cannot say that can we fight against this when they are doing that on their own territories, the states, or their own maritime spaces. What do we try to deal with is when we're dealing with non-national maritime spaces, high seas, the seabed area. That is the importance of this discussion. and a philosophical view that was very interesting. That was that was expressed by Judge Veramantri in the Nagimaros case, where there is the idea of the trusteeship for earth resources as a principle of international law. Well, this is a view that to some extent guides the position adopted by certain states. The idea there is a trusteeship behind the humanity. We can discuss about this idea. So some idealism, and that we need to look at beneficiaries that are beyond the beneficiaries which are the natural ones, the normal ones, not the natural ones, the normal ones. Beneficiaries that are beyond national boundaries, that is international community. Well, he was, to some extent, trying to look at a World Heritage concept. Let us go back to classics. How to look at this? We have maritime spaces subject to national jurisdiction. We're not going to deal with that area. Although conventions, as we mentioned, on biodiversity and other conventions may be addressing the question of biodiversity, but in that limited sphere. We're going to deal with high seas and the area. High seas and the area. Part 7 of the convention, the UN Convention, covers the rights and duties of states on the high seas. Rights and duties of states on the high seas that are subject to a principle which is a fundamental one in the law of the sea, freedom of the high seas. Freedom of the high seas is a question of the right to conduct activities in certain areas, and even to navigate under a high seas regime in certain areas like the economic zone, and with very important consequences. This freedom of the high seas is not only open to coastal states, but also to landlocked states. So it is granted to all states. Very specific freedoms: navigation, overflight, the laying of submarine cables and pipelines, subject to certain regulations, freedom to construct artificial islands and other installations, freedom of fishing, freedom of scientific research. This is very important because freedom of scientific research leads you to the knowledge of resources that are present in the areas, and the freedom to develop knowledge on the basis of the basic knowledge, and the possibility to not only of interventions, but of having more advantages and benefits from that knowledge. The question of patentable knowledge and developments of states, and these freedoms should be exercised with due regard for the interests of other states in their exercise of the freedom of the high seas, and with due regard for the rights under the convention with respect to activities in the area. So there is a limit under the concept of due regard, which is a very important legal term introduced in the UN Convention. Your activities are free, you conduct them freely, but it is not an absolute freedom. You have to take or adopt a due regard approach. So there are limits and there are conditions. This is something which is of interest. Other states and also rights under the convention with respect to the area are, how can we limit, how can we qualify those rights based or rights defined as freedoms, which is not the same, but it is you enjoy and you exercise your rights in a free context, in a free legal setting. What are these? How can we limit? Well, the role of conventions. We have the role of customary law, which is more difficult to introduce in this area of resource exploitation and enjoyment, but and development. But the customary law may be intervening nowadays through certain environmental constraints to resource activities or resource-based activities in open areas, in common spaces. Let us look to another chapter that is also applicable to this subject, Part 12 of the Convention, that imposed general obligations in relation to the protection and preservation of the marine environment. The general obligation to protect and preserve the marine environment is a very rich concept. It is an obligation that is an obligation of conduct, but it may entail other obligations as to adopt preventive measures, response measures, the duty to restore, the duty to have due regard to activities conducted by other states. That is why environmental conventions applicable to navigation and security in international maritime transport, those conventions are of paramount importance to deal with the protection of the marine environment in the high seas and even within areas of domestic jurisdiction. And the convention specifies that those measures under Part 12 are to include those necessary to protect and preserve rare or fragile ecosystems, as well as the habitat of depleted, threatened, or endangered species and other forms of marine life. This is a very interesting concept because it was negotiated before many general environmental regimes were being discussed 10 years earlier than the Rio Conference of 92. So it is very far-reaching, and it was a general conception that has not lost its virtue, its power. It has not been deprived of its power. Yes, states have to cooperate on a global basis, on a regional basis if appropriate, directly or through competent international organizations. International Maritime Organization is one of these entities. IMO, based in London, is one of the entities. Sometimes FAO is important because of the power that has been enhanced, the power of the flag state on vessels conducting fishing activities or involved in fisheries, and so on. But the protection of the marine environment has been also subject to regional developments. We mentioned a moment ago the importance of regional programs, all sources of pollution, the combat of land-based pollution, the dumping at seas, and so on. Very important areas. Let us mention just to identify certain specific areas. The famous MARPOL. It is the convention that dates back to 73 that has been improved by a series of amendments that nowadays envisages the establishment of special areas in the oceans with a more rigorous regime. It is the conditions of navigation, the conditions of dumping or of disposing of waste, garbage, and so on. The discharge of substances, So this is something that has been very important in terms of governance of the high seas, in the seas. Then we have the possibility to designate particularly sensitive sea areas by IMO, through these conventions, through MARPOL. Another area of development where we see this approach, more in-depth approach to deal with this combination or interaction between environment and uses of the sea, transportation. Here it is fishing activities and collection of species. Regional Fisheries Management Organizations, RFMOs. There is an organization in the South Pacific that was adopted in 2009, so it is a very young organization, which is very active in terms of conservation of certain resources, not all sort of ecosystem ingredients, but certain resources. But a very important one, because at the same time it has been a capacity building, if I may say, political capacity building process, because through cooperation in that organization, states learn how to accommodate interest and learn how to introduce economic interest combined with scientific interest to preserve the future life of certain species that were over-collected. Fisheries were so intense that they were exploited at the verge of exhaustion. Then we have other areas in the FAO, as I mentioned. It is the adoption of guidelines for the management of deep sea fisheries in the high seas. Vulnerable marine ecosystems have been identified, and the possibility to introduce procedures for preventing significant adverse impacts from the impacts of bottom trawling. I mean, certain techniques used in fisheries, in fisheries and the collecting of species. So this is very important instruments that have been adopted and that are in place. States have to learn as to how to apply those instruments in order to produce the desired effect. Other questions, special areas. We have it is a very recent concept in the IMO, in MARPOL, of those protected areas, special areas for navigation. But the civil authority has also introduced this concept, areas of particular environmental interest in relation to the Clarion-Clipperton zone in the Pacific, which is an area to the west of Mexico, which is a very rich area in terms of minerals, seabed minerals. Clarion-Clipperton zone, areas of particular environmental interest. What is the importance of this? The importance of this is to set up a number of conditions, elements, in order to have a background, a very demanding background, when exploitation of those resources will take place, to be applied in the circumstances of exploitation. And also, we may find examples in the Convention on Biological Diversity and the possibility to establish ecologically or biologically significant areas to inform and advise sectoral managers of those resources. This is the area. We're going to move ahead, and we look at this another chapter, which is the chapter of marine scientific research. Marine scientific research in the high seas, as we have mentioned, is free. So you don't have to request an international authorization to send a research vessel. You only need resources and the willingness to do this. You don't need to go through an international screening process, which is also interesting, of interest. So this question of marine research being subject to freedom, framework of free framework is something to take into account if we're going to legislate on marine biodiversity, access and benefit. It is not a legal basis to claim resources and to claim part of the environment or its resources. But when you collect the resources, that changes. You can use them for different purposes. You can be very generous with the natural community, but you can also be, let me see, I'm going to continue this. Okay, but you can also have a more generous approach in order to have partnerships, but you can limit your partnership to some identified states or entities. So the question of biodiversity is a very difficult one to tackle and to subject to a regime which is not based on a general agreement. Let us go back to 1992 and the Rio Declaration on Sustainable Development. Some foundations of how to cooperate and why to cooperate. The cooperation is very much entrenched with the idea of sustainable development as defined in 1992. Principle 7 states that states shall cooperate in a spirit of a global partnership to conserve, protect, and restore the health and integrity of the Earth's ecosystem. The idea to different contributions, differentiated responsibilities, and the question of the use of technology and financial resources in a way that could, to some extent, balance what is already very unbalanced. And then the question of jurisdictional formula. So there was the perception already in 1992 that we had to integrate this differentiated approach, but it was not enough. You need something that attracts those who are different to play in a common ground. And this is what is at stake now with biodiversity. The proclamation of marine environment echoes that concept of a common approach with differentiated responsibilities and differentiated interests that are also assessed in the negotiations. And the value of the UN Convention on the Law of the Sea to provide for means through an evolution of the norms, through an evolutionary approach, to have an integrated view of what is essential and what are the components of the global life support system. Very, very interesting. Cooperation. And then we move to another area of the law of the sea. We have the main chapters, the main grounds to look at the issue in general. And we have another chapter of the Law of the Sea Convention, which is the part devoted to scientific development and transfer of technology, which is a very small section of the UN Convention on the Law of the Sea. But that it may be seen as a proclamation of goodwill principles, because it says that states shall cooperate in accordance with their capabilities to promote actively the development and transfer of marine science and technology on fair and reasonable terms and conditions. It is those are enunciations of a positive view towards cooperation, but with very little in terms of specific obligations or specific methods through which this cooperation shall take place. But this is not a negative question. This is a fact, because conventions reflect the political common will, the political common definition or shared definition of what law should be at a certain moment. But this convention is very prone to the application of some evolutionary view on certain concepts. For example, what is to protect the environment? What is to develop marine scientific research and technological capacity? Is it the same as it was in 92, or we have to take into account new possibilities and new interests that have emerged? Even the appearance of new subjects in the international arena. Economic and legal conditions. For example, the convention was adopted in 82. It was amended and it was supplemented in the 90s. 94, 95 with fisheries and trawling stocks. But at the same time, we have the emergence of the WTO regime system that emerged in the 90s. We have other conventions with Rio and Rio Plus, the biodiversity, and so on. The convention, the conservation of biological diversity in 92 has brought into the law of the sea new issues, new ways of thinking, new ways of cooperation, and the possibility to adopt mechanisms. The integrated management and sustainable development of coastal areas, including economic zones, which is part of the Rio and Agenda 21 on oceans and marine environment, is of paramount importance to look at this. Here in Rio, states introduce certain, how can I say, diversification of interest, political interest. We introduced the concept of small islands. Now we speak about small islands as a full-fledged actor in the negotiation on biodiversity, marine biodiversity. Sustainability of small islands. Why is it so? Because of the consciousness that small islands sometimes depend solely or mainly on the development or the conservation of natural resources for tourism, for water, for the question of consumption, for the question of exchanges, and so on, for food, and so on. And another introduction, another concept that was introduced, uncertainties for the management of the marine environment and climate change. The Convention of Climate Change dates from 92, and it has been supplemented and enriched with mechanisms and so on. Let me see, activities to spoil of resources. The Convention on Biological Diversity is a main benchmark to look at biodiversity in marine areas. It does not only apply to marine areas subject to national jurisdiction, it is also land areas where this biodiversity exists. But the question is that the Convention on Biological Diversity states that states have, in accordance with the Charter of the UN and principles of international law, this is a general statement to say that we are going to be legal, the sovereign rights to exploit their own resources, but the ownership of resources is part of the convention, pursuant to their own environmental policies. So it is individual approaches, but subject to the conception that international law is developing. You have to avoid pollution. You have to restore the environment. You have to apply tools to assess environmental impacts and so on. And the responsibility to ensure that activities within the jurisdiction or control do not cause damage to the environment of other states. So the idea of damage prevention. We're not fully in the field of a precautionary principle, but the precautionary approach is fully embedded in the conception of how to conduct these activities. And precaution is a principle, is a subject that will be inspiring from this convention. We put it in the marine biodiversity beyond national jurisdiction sphere. Very important one, or areas beyond. So the question of conduction of activities to ensure not to cause damage to other states or to areas beyond. So it is the national areas and areas beyond where activities are conducted there. It is a different layer, different level of responsibilities. What is biological diversity or diversity according to the convention? It is a very good definition because we can apply this definition to the areas beyond national jurisdiction. Biological diversity means the variability among living organisms from all sources, including terrestrial, marine, and other aquatic ecosystems, and ecological complexes of which they are part. I have to take something from. It includes diversity within species, between species, and of ecosystems. Very important. It is a very large concept. So the picture does not omit any living organisms that may be present in the area. Are we going to apply this definition beyond national jurisdiction? This is something we're going to look at because it is not fully defined yet. And genetic resources, which is part of the one component of this biodiversity. Genetic resources, according to the Organization for Economic Cooperation and Development, which is a definition of that is also present in international law, are genetic material of plants, animals, or microorganisms of value as a resource for future generations of humanity, because they contain the historic codes of heredity. It is the codes that allow the species to reproduce in the future. It is the future generations. Means genetic materials of actual or potential value. The Convention for Biodiversity contains this definition, says that this is genetic material of actual or potential value. And genetic material encompasses, we say, plants, animals, microbial, or other origin containing functional unities of heredity. Functional unities. So we have genes, the plants have genes, the animals have genes, and it is the functional unit of heredity. It is absolutely unbelievable. We have here a picture where we see bacteria, phytoplankton, zooplankton, and vertebrates. And there we go to human beings as part of the animals, or as different from animals. This may be even a philosophical question. The jurisdictional scope of the CBD, we have already mentioned, it is national jurisdiction and beyond national jurisdiction when it deals with processes and activities of entities subject to the nationality. So it is also applicable in the high seas, whether there is an entity that is subject to the state. But that creates certain questions, certain issues of legal issues. The convention has been supplemented by other conventions, which is the most significant ones are the Nagoya Protocol, that provides a model for fair and equitable sharing of the benefits arising from both the use of resources and the use of traditional knowledge. I have checked that Brazil is party to the Nagoya Protocol. Chile is not party to it. I don't know exactly which is the problem. Sometimes it is a domestic problem that prevents governments to go beyond the signature. Ragione materia, and then the Nagoya Protocol has certain provisions to comply with, obligations to develop domestic legislation, and so on. But it's a very important question, which is the way to learn how to deal with biodiversity and genetic resources. It is that it implies prior informed consent, and the mutually agreed terms have been established. So if an operator X, a laboratory from a foreign country, comes to your state to take genetic resources to develop research, you have to provide for informed consent. I think this is a very important issue, because most of the time many times you notice universities, scientific laboratories, which are public ones, very knowledgeable, with highly reputed laboratories. They may take samples because they go to the coastal areas, they take plants, animals, insects, and so on, and they can develop a knowledge only for scientific purposes, but they can also identify proteins, they can identify other materials that are not genetic resources, and they can develop some new, species, or they can that could be patented. So this is very important. So to have mutually agreed terms in order to have access to this. The Nagoya Protocols, access obligations, clear rules, and so on. The idea is to share benefits. I don't know which is the experience of countries that are party to those to that protocol. Another convention, which was negotiated in the framework of the FAO, it is International Treaty on Plant Genetic Resources for Food and Agriculture. It is the idea to protect plant genetic resources and to have, to some extent, some systems to provide for conservation, to conserve, to keep those resources for future developments. It is to provide access to genetic resources for research, training, and breeding, but at the same time, states can collect and have a kind of reservoir of their genetic resources internally, seeds, especially plant seeds, and so on. It is very important. Chile is party to this. I think Brazil is also party to this, and to have means for conservation and sustainable use of plant genetic resources. So to know what you have on your territory. You have, for example, genetic resources like potatoes, mais, to have for wheat, for plants. Well, Brazil is a full natural laboratory for this, and to have standard material transfer agreements, so states can know what operators or what contract are doing with the species that are involved in this protection agreement. So 64 species are involved, and marine genetic resources could be envisioned. And then we have the Cartagena Protocol for living modified mechanisms, which is very controversial for some states and in some cases. And Chile is not party to the Cartagena, but I think some Latin American countries, including Brazil, are parties to it. So we have to look at the experience, how states are dealing with marine genetic resources and genetic resources, land-based genetic resources, in accordance with certain conventions and legal frameworks that are already in force, which are not universal, but are already in force. And now we move directly to BBNJ, biodiversity beyond national jurisdiction, taking into account this very general and already complex framework. Three main concepts, and we will stop now because we will have some questions if you want to. We have the classic classification of regimes. Res nullius, you conduct scientific research on resources that are res nullius, so you can appropriate, you can collect and transform those resources into their own ones. Res communis, so they are not subject to state entitlements, but they belong to the whole community. So the management can be made collectively without individual appropriations or individual allocation of areas for individual exploitation. Common heritage of mankind, which has an inherent element, which is the non-appropriation and non-sovereignty, and also the sharing of benefits. Common heritage of mankind means that benefits are not only to be granted to individual states or operators, but to other states that are not operating, but maybe in need. And if we introduce more elements, we have also the question of the impact of resource collection on the high seas to those states that are producing the same resources domestically. Marine genetic resources of areas in areas beyond national jurisdiction have been of free access for years. Since 1992, Rio, that's why we put Rio in our slides, there has been a growing concern about how to interrelate this access issue into more complex pictures and scenarios because of environmental degradation, because the capacity to exploit the responses, the development of capacities, the need of conservation, the introduction of the concept of sustainable use, or to use sustainably marine resources, and so on. And because of the evolution of the work of the civil authority on minerals, where the first discussion took place. Should we deal with minerals plus biodiversity in the same framework? The decision was not a positive one. There was no decision in that direction. It doesn't mean that there was no decision at all, because the decision was to move into the UN setting, not the seabed authority setting. But we cannot ignore that there is a relationship between the future regime and the seabed regime, politically speaking, economically speaking, and also scientifically. With this, I would like to take one question to two questions, if you want. I can stop sharing there. If you want, Professor Marcílio.
Thank you, Maria Teresa. Thank you very much for your presentation. It was very insightful, interesting, very plural. I'm sure that only a person like you with different hats, diplomat, judge, professor, could be so plural in your presentation. Thank you very much. So I think we have 2 or 3 minutes for some questions. I don't know if we have already, but I have one question. I have a personal doubt. Once you mentioned the ocean governance, and I would like to know if in your career, did you have chance to deal with the intersection between law of the sea and international cultural heritage law? I remember, for example, now the 2001 UNESCO conference on underwater cultural heritage. So I was thinking about if it's another example of this complex governance of oceans and so on.
It is professional. It is, in fact, I personally was not involved in the studies conducted to that convention or the discussions underlying the negotiation. But I'm aware of the importance of developing certain principles and certain criteria to deal with this. I think the law of the sea is the foundation. I mean, the law of the sea jurisdictional allocation of zones is the foundation of to look at the entitlement of states and third states. We can discuss further it tomorrow, but I think in the application of the convention, in which I don't see in our country many controversies, as in other areas where seas are so enclosed that there have been many activities, even opposing activities being conducted and vessels being discovered and the treasures and so on. But what I have seen is that the question of the importance of anticipating solutions when you have economic disputes between founders, discoverers, states, and then the state of origin of the goods that are on the seabed or that are found on the seabed or the seafloor, better said. And I think this is a very important development in international law, because we have to anticipate adventurers also, and people who are going to play in the ground of gambling because of these developments. And the attachment of the goods to the coastal state or to the history of certain communities is of paramount importance. Traditional and historical appartenance is also very important. And I think we benefit to some extent with the jurisdictional exercise that convention has brought into the international practice. Because states had certain knowledge and certain experience in certain areas, but regarding species and cultural resources, cultural heritage, this is a more new area, new in terms of the humanity. Some decades have lapsed, but this is important. So the international law has been spanning in areas where you can find the importance of jurisdictional grounds, national shared jurisdiction, like in the common spaces and so on, interplays, and the practice on cultural heritage is very important to identify what are the problems we have to deal with.
Mm-hmm. Okay, thank you.
Yes.
Judge Maria Teresa, what I would propose now is to stop here and to obey the schedule of SEDIN, and then we continue tomorrow with the second part of your conference.
The second part. of the explanation. Thank you very much.
And then we have more time to present some other questions and discuss with the students.
No problem. I try to yes, I will leave more time for questions. Thank you very much for your patience and your attention.
Once again, thank you. Thank you very much.
Yes,
and I invite all the...
Yes, Tatiana, Fernando.
Fernanda, yes. And I invite all the audience to be here tomorrow for the second part. Okay, thank you.
See you tomorrow.
Thank you, Professor.
See
See
you
you tomorrow.
See you tomorrow.